Yeah. Okay. Waiting for the YouTube stream to start. We can get this going. Very good. All right, to start this concurrent meeting of the Easton Reading Region 9 Boards of Education, I'll call to order the Easton Board and ask that my fellow board chairs do the same. Members in attendance for the Easton Board: Devin Weibel, Jenny Chia, Jen DeJesus, Randy Hicks, and Jeff Parker on Zoom, and myself, I'm here as well, John Stinson. Ready?
Calls to order this special meeting, the Reading Board of Education at 7:39 p.m. on January 6, 2022. Present in person, myself, Chris Parkin, Stephanie alternate Charles Sadana, and by Zoom, Morgan.
Call to order the Region 9 special meeting for January 6th, 7:39 as well. Members present are Kathy Thompson, Sarah Lieber, Karen O'Brien, Mary Lee Campbell, Cheryl Graziano, Todd Johnson.
Thank you, Mike. We'll start with public comment tonight. No members of the public being present. We'll move to board member comment. We'll start with the Easton Board. Any public comment from the Easton Board?
I just wanted to welcome new members. It's our first meeting with a lot of new faces, so glad to see them.
Thank you, Jenny. Any other comments from the Easton Board? Jeff or Randy?
No.
No. I also just want to welcome new members. It's really great to see new faces here, and I'm excited to get a lot of great work done. Ready?
Echo the same comments. Eastern Board, you look so different.
We never change. All right, thank you, Chris. Mike?
Region 9 Board, anyone have comments? I echo again and welcome Kathy Thompson and welcome to the returning members. Looking forward to another great year.
All right, we're going to move on to a presentation. I'll allow Dr. McKinnon to introduce our guest, Rebecca Santiago, in a moment. Did you want to tee this up at all?
Yeah, that'd be great. Yeah, thank you so much. Well, good evening, everyone, and welcome. And for those of you watching at home, thank you for tuning in. It's my honor to introduce Rebecca Santiago, who is an attorney from Shipman and Goodwin. I've worked with Rebecca in different roles and in different school districts, and we have presented this presentation in the past, and I think you'll find it informative, especially for new board members. And there's also some information that sitting board members might find informative as well. So that's just a brief introduction. I'd just like to welcome Rebecca and thank you for coming.
Thank you for having me.
All right, so I have the PowerPoint here that has been converted to PDF, so it should have all the content there. I can hand you the mouse and you can advance your slides, or I can be, you know,
Vanna,
I can be Vanna White if that's what you like.
you look like you'd make a heck of a Vanna
Thank
White.
you. I appreciate that.
So I'll let, then I don't have to
Okay,
trample over all the courts.
and I won't be offended if you change your mind a couple slides in.
If I decide that you're not as good as Vanna, you know, this provides a little entertainment value, right? So thank you guys so much for having me here today. Can everyone hear me? I'm sorry about never get used to the mask. No matter how many hearings and things I have to do. Wearing one now, it's still a little bit hard to project. So if you can't hear me, wiggle, do something so that I'll try to project a
We can
little
hear
bit
you.
better.
Can our Zoom folks here?
Yeah, can Zoom all hear?
Yep, we can hear fine. I can.
And you have the presentation, yes? This is not letting me share the screen to share. You all have the presentation?
That's right.
That is correct.
Okay, great. So as Dr. McKinnon said, he and I have worked together in several other districts. I am a school lawyer from Shipman and Goodwin. I work with lots of districts across the state. You know, They don't make it easy on me, so it's everything from one end of the state to the other end of the state, Ridgefield I work with, and then all the way out in South Windsor, in Hartford. So all over the place, do all kinds of school law. I do everything. I do everything from special education to labor and to advising boards about policies and other legal matters. So I'm very excited to be here with you today. I hope I can be helpful. Please do stop me if there are questions. I know that there are lots of people who are very seasoned and that there are others who are new. So I welcome any questions, and I want it to be useful for both types of board members. So what I'm going to do tonight is I'm going to talk a little bit about the roles and responsibilities of the Board of Education. I'm going to talk a little bit about board meetings, particularly for new board members. I think it's helpful to hit the freedom of information basics. I would like to talk to you a little bit about electronic communications. I put public comment as one of the topics that I'm going to go over tonight, just because that's also something that I get a lot of questions about in my practice. And then maybe we can work together to talk a little bit about some best practices for boards to utilize in order to work well with administration, work well with each other, and accomplish the goals of your districts. So that's my agenda for the evening. As I said, if there's topics that are related, feel free to ask questions, or we can ask questions at the end. Happy to be useful. So the first slide that you have up on the screen talks a little bit about the board generally. A board of education is a function of statute, as you probably all know, right? You're an agent of the state, you're created by statute. And when you're an entity that's created by statute, that means that the statute defines the functions that you can serve. And it limits that too, right? So the statute itself, the statutory framework sets forth what functions you can serve and what functions you cannot. Statute also defines that a superintendent serves a certain role that works in collaboration with boards of education. The superintendent in particular, by statute, is defined as the chief executive officer of the board. And as such, what that looks like on a day-to-day basis is that you guys are the big picture, right? You guys get to do the policy making, the goal setting, and the administration, as led by your superintendent, does the day-to-day operations. And I think that that's important to start with, because a lot of new board members may not understand what the function is and the limitations. And also the scope, because you do have very broad oversight responsibilities, but the day-to-day operations are limited by statute and also by certain other statutory factors, which we're going to talk about tonight. All right, Anna. So the first, when we talk about board members and the scope of their authority, as I noted, the day-to-day operations are run by administration. So not surprisingly, you have a bylaw, which most districts have a bylaw that says something very similar to this, that defines the scope of board members and says that board members, although they're a public official, that their job is not to direct the day-to-day operations of the school. Their job is not to call the principal and say, here's how I think you should run the third grade, or here's how I think you should staff your building. Instead, it's much more of a broad, overarching policymaker, goal-setting kind of role. And so not surprisingly, you have a bylaw that explicitly states that that is not your function. Also, it's important, I think, as board members to know that you really can only operate as an entity. Individual board members do not have the authority to take action on their own. And the board cannot take action except authorized at a meeting. This, I tell you, before you get barraged, or maybe you've already been barraged at the supermarket, but the public doesn't always understand this, right? The public doesn't always understand that when they elect you to come and to serve this very important role, then that it isn't your role to be able to call up the principal and be able to snap your fingers and have something change, or call up the superintendent and direct, now here's how this is how we're gonna now teach the third grade. That's not your role. That doesn't mean that it's not very important for you to be aware of your stakeholders and for you to have good, solid communications. And we're gonna talk about some best practices, because I don't want you to hear me saying you shouldn't be interested in what the public says. But I think it's really important that you know, and that, so that you can explain to the public that as a function of statute and as a function of how the board operates, individual board members are not empowered to make decisions as one unit, as one person. The only way that the board acts is at a meeting like this, by motion, or there are occasions where a board could make a motion to empower a particular board member to serve in a certain function. But absent that, an individual member does not act alone. Any questions about any of that? Okay. Usually after I scare people about the fact that they can make motions and that they can make decisions on behalf of the board, they want to know, is there any protection for board members? So my next slide, I just want to quickly put your mind at ease that there is a statute in Connecticut that is the Indemnification Statute that covers board members. So board members, as long as you do not act in a manner that is wanton, reckless, or malicious, then under statute, the actions of the board or individual board members are indemnified. Meaning that if the school district, one of your schools, if Easton was sued, if Reading was sued, if Region 9 was sued for a decision made by the board, the individual board members would be indemnified, meaning that the district would provide you, would provide you with defense and would indemnify you from those claims as long as you do not act wanton, reckless, and malicious. So that begs the question, of course, is what does that mean to act wanton, reckless, and malicious? Who wants to give it a guess?
Authorizing a contract, a 3-year contract for buses.
Well, what would you do? If you don't want it to be wanton, reckless, or malicious, right? It should be within the scope of what's reasonable, right? Based on, let's talk about buses, right? We're talking about buses. So as long as your contract is within the scope of reasonableness, based on data, not just, reckless, malicious, not just, hey, I think the bus company deserves a 20% increase, or hey, I think that the buses should get 0 and then no one can drive the students. As long as it's reasonable, it's based on fact, it's not going to be wanton, reckless, and malicious. And I'm quite confident that all of you can consider the facts in front of you, can make decisions that are consistent with your policies, that are ethical, and that are based on facts and not just reckless or malicious behavior. So I think hopefully this slide gives you some comfort in the fact that you should be proud that you took on this role, you're protected by the statute, and that now you're empowered to make good decisions on behalf of your school district. All right, I want to talk next briefly. Another question that I get when I'm just talking about general board functions is the role of the chair. This is your bylaw. This is the Region 9 bylaw on the role of the chair. Essentially, like in most districts, the chair's main functions are that there's an ability to call meetings. The chair has the ability to appoint members to committees. The chair serves as a resource to the superintendent. So although I've stated that the superintendent is responsible for the day-to-day operations, the chair does serve as someone who the superintendent can contact and process issues with from time to time. And then I think number 7 is very important, is that the chair often serves as the liaison between board members and the superintendent. I think it's really important when I talk when I talk about any board, is to set up a process of communication. If an individual board member has a question for the superintendent, does the individual board member contact the superintendent directly? Or does the individual board member contact the chair who determines, oh, we have that information and I can give it to you, or, oh, that's a good question, to go to the superintendent. I think your bylaw implies that the chair exercises some control over that so that we can balance the requests and make sure that we're not overwhelming the superintendent with requests that the chair may be able to advise without seeking information. Is that how it functions here for the new board members?
Depends which of the three boards you're talking about.
Right, I know, it's complicated here, but I think that that's helpful, but if it's helpful to chime in and tell them how this is an opportunity for you to share it with your new board members, how you want that level of communication to go. We don't have to, but okay. Your bylaw implies that there's some level of filtering, which I think is beneficial. Duties of board members is my next slide. So we've already, in terms of what board members are responsible for, right? We're responsible for making policy decisions you alluded to. We're responsible for running meetings. Another really important function of the Board of Education is that in certain instances, the statutes direct you to serve in a quasi-judicial function. So what that means is that essentially you serve as the hearing officer or the judge in certain types of hearings. Specifically, those types of hearings are expulsion hearings, residency and transportation hearings. So those would be topics about transportation hearings pertain to bus stops. If a parent believes that their transportation or their walking route is unsafe, you probably have a transportation policy that dictates the safety guidelines, and there's a hearing protocol by which a parent could request a hearing in front of any of the boards to address that. And in that role, the board would serve as a hearing officer. Teacher termination hearings is a very important one for a variety of reasons. Obviously, teachers and teacher employment is a huge piece. It's for not everything of a school district, but it's a large part of the function of a school district. And a very, very, very important role that boards of education play is that in the teacher tenure process in Connecticut, the hearing process is run by the board. So the way it works, really quick and dirty summary of the teacher tenure law in Connecticut is that once teachers attain tenure, which can happen after 2 years or 4 years, depending on whether they've been tenured prior, they have certain protections. If the district believes they have done something for which termination could result, the teacher has the right to request a hearing. The hearing for non-tenured teachers is always in front of the Board of Education. For tenured teachers, it is a choice between, the teacher has a choice between holding it in front of the Board of Education or an impartial hearing officer. But even if that teacher has an impartial hearing officer hear the issue, the hearing officer's determination is then brought to the board to make a determination as to whether or not the teacher's contract is actually severed. So why is that important? It's important because you're serving in a quasi-judicial function in a tenure proceeding. In order to be quasi-judicial, you have to be impartial. So what that means is that you need to come into that hearing with the least amount of external information that you can, right? Because being impartial means making a decision based on the information in front of you in the hearing presented by the administration. Why is this important? Because when next time, if there's some issue that arises and you call Dr. McKinnon and you say, hey, I heard there's a major issue going on. Can you tell me what's happening with so-and-so teacher? And he says, well, I can't go into the details of that, right? The basis of that very well might be because of this very important role that you serve, he needs to keep you impartial. So although he may wish to give you much more information than he's able to give you. If there's a possibility that that teacher ends up in a hearing in front of you, he can't explain all the details until he gets in front of you so that he can keep that impartiality. And I think that's very important for new board members to know, because I oftentimes it's a point of frustration. They contact superintendent, they say, hey, I know Mrs. Jones is having major issues. Tell me what's going on with Mrs. Jones. I'm getting all these complaints. And the superintendent says, I wish I could tell you about Mrs. Jones, but I really can't tell you about Mrs. Jones because of your role in the tenure process. So now I'm hoping that helps to explain that, because a lot of times I know superintendents wish they could say more. What most superintendents will do, they will say, Mrs. Jones was on administrative duty. Yes, there are concerns about Mrs. Jones that we're looking into them, but I can't go further. So if those things happen, now you know the legal basis or why. Yes,
Are these hearings public meetings?
tenure hearing?
Any of these in the 1 through 4 here are
So
some,
it depends on the circumstances. So like an expulsion hearing, for instance, is generally not because of FERPA. So another law, which is going to come up a little later in the presentation, but I'll just jump and explain it now. So all student matters are protected by federal law, which is FERPA, the Family Educational Rights and Privacy Act, which states that student information is confidential and may not be disclosed to anyone other than the student's parent without consent or specific exceptions. So because an expulsion hearing, obviously you're going to be reviewing confidential student records and confidential student information. Generally, that's going to be held in executive session because there's a reason. Similarly, transportation hearing, if there's all kinds of documents about a particular student, it's likely to be held in executive session. Same thing with residency. Teacher termination hearings are, and grievance hearings are a little bit different. There's certain pieces, like a grievance hearing, there's pieces of it that are held in public session and pieces of it that are held in private. A teacher termination hearing, there's one of the reasons that you could hold an executive session is a personnel matter. So obviously a teacher's employment status is a personnel matter. Most times teachers seek to have it in executive session, so we would do it that way and be respectful of the teacher's privacy. Grievance hearings is the last thing that I was going to go over. And grievance hearings, those are a function of collective bargaining. I don't know how many of you have served on negotiations, but in each of your collective bargaining agreements, you likely have a section called the Grievance Procedure. And what that section is that if one of your employees believes that a portion of your collective bargaining agreement is violated, they have the right to bring the hearing or seek to have the board adjust or address the alleged violation of the contract. That in that capacity, you actually don't act in a quasi-judicial capacity, so that's why I've noted that it's a little bit different than these other types of hearings. And you are actually allowed to talk to administration, so administration can tell you what's going on in a grievance because you are the same party, you aren't acting in a quasi-judicial fashion. But in those hearings, the evidentiary portion is generally in public, but one of the exemptions under the Freedom of Information Act for public meetings is collective bargaining. And so the deliberation as to whether or not it's a violation of the contract is not a meeting and can be done outside of the public. So hopefully that makes sense, but.
Rebecca, when you talk about residency, expulsion, and renewal hearings being primarily an executive session, the ultimate vote and resolution has to still be in public.
Of course, yes. We're going to talk in a moment about executive session. So executive session allows you to have it discussed in outside of the public realm, typically because there's some reason for it, right? For personnel matters, it's to protect the privacy of the personnel issue. For student matters, it's to protect the privacy of the student. But the ultimate decision has to be made. There is no, the board cannot act in executive session. No action can be taken in executive session, only discussion. So you would have to come, so if you were having an expulsion hearing, you have the hearing in executive session, you come back into public session, you don't say the student's name, you just make a motion. The board moves to expel student A, and that's what it's got. Any other questions about your quasi judicial role? That one usually gets people more upset, but you know. You're a tough crowd. Vanna, get them going a little bit. All right. Impartiality, I think I've covered the impartiality slide. This is just the notes of what I just said out loud, so we don't need to cover that one. All right. Should we try a scenario? Let's do a little scenario related to some of the things we've just gone over. So yesterday, the local newspaper reported that a teacher in the district was recently arrested on charges of selling narcotics. The article identifies the teacher by name and the school. The article quotes the superintendent as confirming that the teacher is on administrative leave with pay pending investigation. During public comment at the next board meeting, numerous parents demand that the board fire the teacher immediately. During the meeting, one board member exchanges text messages with several of the parents who have spoken. No need to worry, we've got this. I assure you that teacher is toast. Should the board be concerned about the board member's actions? Who sees anything concerning? Ding, 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 Vanna.
Yes, the board should be concerned about the board member's actions,
All right, why?
because that board member has no authority to make any such assurances.
True, exactly. So the board member they can't act as one person, right? So they can't assure anybody that the teacher is toast. What else?
They haven't had a hearing yet.
They haven't had a hearing yet, right? And
They've
so it's a
already made
little
up their mind.
concerning that they're texting the parents, right? They're certainly questioning their impartiality, right? Any other concerning things?
They can't speak as
They can't speak as an individual, and I think that's important too. I think it's very important. I didn't cover this as directly when I talked about the chair, but I think it's important too to decide who speaks for the board. Do individual members speak for the board? How do we address ourselves? I mean, I think it's, people are going to know that you serve in this role, so I'm certainly not telling you to hide that you serve in this capacity. But it's very important that when you speak now, that you're clear that whether you're speaking as you, the individual, or whether you're speaking on behalf of the board. And the only way you can speak on behalf of the board, as I said before, is if you've been authorized to do so. So that's another concerning piece. Anything else?
now a written record.
Obviously, there's some liability concerns here, right? What happens if it turns out that it wasn't narcotics, it was oregano or whatever? You know, who knows? It was something not accurate, right? What if this turns out to be not true? And we've said, no need to worry, we've got this. And we've potentially affected that teacher's reputation. That's a problem, right? So there's some liability concerns here. We want to be very careful about what we say and who we say it to. The other piece here that concerns me is how do they even know who got this? Whose job is it to investigate? The administration, right? So this board member hasn't talked to the superintendent because all this is playing out in a meeting, right? They don't know whether the superintendent, maybe the superintendent put the person on administrative leave. They're investigating it. We have no idea what the status of that investigation is. A lot of times teachers are out on administrative leave because out of an abundance of caution, right? Because we can't not take a narcotics claim seriously. We don't know whether it's valid or it's invalid, right? And so I think it's very important to remember the role and remember what information you do know, what information you are able to communicate. All those things are really important.
So under the indemnification piece, would that be considered wanton, reckless, and malicious or malicious? That text?
I mean, I don't, obviously, my job is to defend you, so I think nothing. Right, it's a very high standard, Kathy. But I think, you know, I wouldn't do it. Yeah, I'll say that.
Is it,
I would defend you zealously, but.
is it inappropriate for board members to be texting a parent about a topic, period, regardless of what that topic is?
I wouldn't do it as a general member because it's not, as an individual board member, right? It's not even really your role to speak on behalf of the board. Do I think it's possible to never text a parent? Probably not, because I'm gonna be honest with you, parents are gonna contact you. But I think what's important to know is how you respond. So if a parent contacts you and says, I'm so upset about the teacher who's in the newspaper, you have to say, you need to talk to administration. My role is not to deal with personnel matters. I would love to help you. I understand why you're concerned. Those kinds of things are perfectly fine. What you don't want to do is get into the substance of it, because it's not your role, and that's great, because for indemnification purposes, you should not want it to be your role. Let him take on the risk, right? It's not your role. So I think it's important to be able to say to that person, I understand why you're concerned. I hear you. You have valid questions. I am just not the right party to address them.
But even that exchange, should that be ported over to like their email so that they go to, a record in case?
Yeah, I mean, text messages in general are not the greatest method, right? So I wouldn't use it as a method of communication. But if some parent text message you, I'm just saying, it's okay to email them back and say, I'm not the appropriate party, or to reach out to the chair is probably even better. Reach out to the chair. I received this inquiry. Can you follow up with that person and say that I hear them, that we hear them, that we take this seriously, but the board's role is not this. Text is not the best place to do communication, period, obviously. And I'm going to talk in a minute about freedom of information, but whatever you do put, whether it's text, whether it's email, whether it's on your personal computer, your personal phone, whatever, if it's about board business, it is a public record. So if you start using your phone for public business, then you are creating public records on your phone. And here's an even scarier thing. Technically, the Freedom of Information Commission could ask to see your phone and to see your text, or your home computer, or wherever it is that I have, in extreme cases, there have been instances where they have said, we don't believe that you're producing all the information. I want to go through your personal inbox. So if you open up those lines of communication, you open yourself up to those things. So absolutely, I agree. The better way would be to communicate on email or something official, to have a person who's usually the point person, typically the chair, and to be very clear about what your role is and what your role is not.
I would simply, if a parent contacts you and it's by email and they have a concern about lunch at school, forward, thank you very much for your email. I'm going to forward this to Dr. McKenna. Maybe a copy of board chair. And that is the simplest way to handle that. If the content is something more worrisome, I wouldn't forward it at all. I'd be very careful about forwarding anything and then just forward.
Pick up the phone and say to the chair or Dr., depending on how you want to handle that communication piece that I was talking about before, but pick up the phone and say, I received the same word. That's fine. And certainly, I agree, we shouldn't encourage people. I'm just being honest with you that some people will probably reach out to you that happens. So it's important to know how to respond. Okay. As a follow-up to our scenario on my next slide, Vanna, is a couple of important considerations. I think we've mentioned FERPA already. So one piece that also comes up in that particular scenario was about a teacher. So, but if this was about a student, so let's say a person contacts you to follow up on our conversation about inquiries from parents. If a parent were to contact you and say, this such and such is going on in my third grade classroom, can you tell me about it? FERPA comes into play because just as it means that we can't reveal confidential information about students in a hearing, we can't reveal it to people who don't have a legitimate educational interest, and at times that includes you. So or the person who's asking you about the information, right? So if it's about their child, so if a parent contacts you and says it's about their child, refer them to administration. Usually with that kind of thing, it's building level, not even Dr. McKinnon, but in any case, refer them to administration. Administration, if it's appropriate were to ask questions about specific students who are not your own, you may be told even that we cannot provide that information because we don't have parental consent. There is an exception to FERPA for district officials. They can have access to certain information, but the only time you can have access to that information is when you have a legitimate educational interest to know. There may be times you do have a legitimate educational interest to know. There's a lawsuit, right? There's a lawsuit and you need to know what's going on because you need to make a decision about how to allocate board resources to resolve that matter. Maybe you have a legitimate educational interest to know. But other times where you're not involved in a particular incident, you may be told, although we would like to provide you that information, please know we're handling it, but we can't share the information with you. We'll follow up with the parent director.
Rebecca, that gets into sort of a sensitive topic around special education, which every year consumes a bigger portion of our budget
Yes,
and creates more public scrutiny as to why that continues to expand.
yes,
And we're frequently asked, well, there are 7 or 8 kids outplaced. Where are they going? How expensive are they? Why?
right.
And we're not entitled to that information, nor are
Correct.
they. And so how do you balance that, particularly when you talk about educational need to know as far as settlements are concerned, to the extent that settlements are delegated to the administration versus the extent that they are?
Correct. So you wouldn't really be involved in a settlement discussion. So this is a strain in many districts. And it's complicated and it's frustrating because there's a tension between your role as being responsible for the budget and the fact that you aren't making the decisions. But in the special ed front, what's complicated about it is that under the statutory scheme that pertains to special education, which is the IDEA, the Individuals with Disabilities in Education Act, it specifically says that the people who are empowered to make educational decisions are the planning and placement team, which you are not. So it puts us in this place where there's a tension, where it's very difficult to say that a board would have a legitimate educational interest to know when legally they are not empowered to make those decisions. So the reason that we generally say that we won't provide the specific details about a particular student to the board is for that reason, is that the legal construct is that decisions about that child's education, including whether there's a settlement agreement, including are made by particular people who are empowered by the law to make those decisions, and it's not the board. So that's why generally we can't provide that type of information. What we can provide are things in the aggregate. We can say, how much particular outplacement you'll see in the budget, how much particular, how much outplacements cost in the aggregate. And then you have to trust that your superintendent, who is responsible for supervising all staff, is making sure that your director of special education is making sound educational decisions and not outplacing students who could be better served in a less restrictive environment, right? So essentially, hopefully that provides some clarity, but unfortunately, really the only times in my career where we have come to boards to talk specifically about special education matters have been when it comes to the court level. Sometimes we will come because it really is a litigation decision where the party is now the board, and the board has to decide whether to resolve it. But prior to that, the decisions are really being made by the planning and placement team of which the board is not a member.
The ultimate public relations trick is convincing the public and the
That-
funding authorities that 34% of our budget is a black box and you just have to accept it. basically.
I can't argue with you as being challenging. I wish I had if I had the magical solution to that, right? I'd probably be a very wealthy woman. But no, I think it's important to just explain that that we obviously take that number very seriously and make those decisions very cautiously. And then our goal is always to try to educate students in the least restrictive environment whenever it's possible, but that there are times when it's simply not possible. And that it's just as costly to make a decision that isn't in their best interest, both on the student, because it's harmful to put a student in a placement that's not appropriate, and also on the district, because believe me, the litigation that can ensue when a student isn't served in the right placement is also costly. So I believe you, I hear you, I feel your pain, but that's hopefully some education as to the legal basis for it and some information perhaps you could share with the public as to why we have to handle it that way. Okay, and sure.
The board can always hear financial. In other words, everything is geared towards the confidentiality of the student. You don't want to release any kind of details that would be personally identifiable. So when you talk about certain outplacement services or something like that, you can't really speak about that because there's a chance that you can identify the child indirectly. But we frequently ask about whether there are any outstanding due process issues, the extent of cost, stuff like that can be relayed to the board.
Yes.
As long as we don't get into anything as far as services or anything that's identifiable.
The hard thing that gets to that tension is that then, like, if you're told there's a pending due process matter, oftentimes we can't explain the details of the due process thing because it would reveal that personal identifiable information. But yes, certainly if you have questions like, is there an upcoming due process hearing that would be costly towards the district? That's a fair question in your budgeting role. Yes.
I have a question. Related to this topic, I've some savvy parents in the district. I've been asked pretty tough questions kind of around the topic that Chris is talking about, specifically about outplacements. And if we have adequate representation on our side in those hearings, or if we're just getting bullied into doing something that a parent wanted versus what's best for the kid. That's, and I have a hard time answering that one because I don't know that we do have adequate representation every time. And I don't sit in on those meetings. I don't know, is it routine for us, you're our shipping contact, or is it routine for us to have somebody in those hearings?
Of course.
Because I feel like we have an excellent program, special ed program. We offer a lot of services, and if it's just a difference of opinion, I don't think you offer what my student needs versus we say, no, I think we can serve your student here. That's probably a pretty tough meeting. I don't know if you've had a chance to be in on anything like that yet, Jason, but I know those have happened.
They are very complicated. Jason, if you want to chime in, you certainly can, but we do have legal counsel. It's not me, but I do serve that role in many, many other districts, which is why I can speak about special education. Because I do back my day. It's a complicated thing, and you're not going to be able to tell a parent who's not that parent the details of the complicated decisions. But oftentimes it's a decision about what's best for the student, as well as an analysis of the relative risk in the case. Those hearings are incredibly complicated, incredibly lengthy, incredibly expensive. So sometimes it also is a business judgment of weighing the risk of going forward with litigation versus what's being requested and what's best for the child. But ultimately, those decisions should always be, based on balancing of the best interest of the district and the best interest of the student. But yes.
Should we have representation at those meetings?
You do have legal counsel at, Jason can answer, but if you had a hearing, you would absolutely have a legal counsel, I would imagine. And if you had mediation, you would typically have legal counsel. I don't know if that's,
I think what
not
might
in
be,
every
might be,
single PPT.
might be intimating there are PPTs where we might have some aggressive parties on behalf of the students, and the administration isn't represented by counsel. Those instances, he's concerned that they're being overrun in those.
I see. Well, so some of that, I don't know that I can answer that, but I think you'd have to decide whether, one, your staff needs more training, because that's one way to address that. Two, it's a balance, because you don't want to have an attorney at every single meeting either, because that also sets a particular tone, right? So there's a balance to when to utilize that legal support.
And to be clear, this is all anecdotal. This is not a suggestion.
I guess I would want Jason to know that, as a board member, I feel like if we feel we can really serve a student here in district, then we need to, we need representation to make that case. I sure would support it.
I my philosophy is to always, find the best program for a particular student. And if I believe that we have a strong program, then that's my tone. Some districts fight with parents and have that stance even when they don't have a strong program because they just want to take that position. And I'm a former special education teacher and a teacher as well. So I'm always interested in building consensus, having a strong relationship with parents, not inviting an attorney to a meeting if we don't need to. However, Rebecca has a lot of skill in this area and she does, and we have worked together and you have been to mediations and settlement discussions. A lot of times, believe it or not, a skilled attorney can actually bring down the heat of some certain situations, and in a lot of ways we do that. So it all depends on the situation, but we offer a continuum of services. We try to offer them and develop the best programs we can. And some of the conversations we'll have during the budget process will talk about how if we develop these strong programs, it will actually keep our students in district, which is better for our students and less costly than sending them out. So I do wrestle with the idea of these are our tuition and transportation costs outside of the district and what our outplacements are. And sometimes I know that there are potential outplacements, and I think about how we're going to record that in the budget for the purposes of budgeting without forecasting what our move is going to be. So sometimes districts call that contingency for special education. Sometimes they call it, these are our known placements and our unknown placements. Or sometimes they look at the history of the last 3 years and what our outplacements have been and what our surprises are. And typically there are a couple of surprises each year where 2 or 3 students are outplaced. What is the average expense of those outplacements and we try to factor in the placement, but it's difficult. But you have been involved in mediations and settlements and PPTs, right?
Absolutely.
Yep, and we've sat in a few PPTs.
We have.
Yep.
We have. Yes. No, I mean, I think definitely in the PPT, you're not going to always take the tact of what's on my way or the highway, as in any meeting, right? That's never the best tact. You have to decide based on specific facts in front of you. Some students are going to do beautifully in district, and other students are going to need something more. And it depends on the specific facts. And you have to weigh the risk. And, I think most of us do this all the time, have a sense of how to do this. But hopefully that gives you some information to understand some of the thinking that goes into this. We can certainly further the conversation if you have other questions about special
Thank you.
education. I'm more than happy to
Appreciate
stay
it.
after and answer them. Okay. Other statutory duties. Well, we can-
Sorry, before we jump in, I can't focus because I'm thinking of you standing there for an hour and continuing to stand. We have a table right there with the chair. Would you be open to us moving this over here so you can sit, or?
I certainly can. I don't mind either, though.
Okay.
I'm fine, but thank you. That's so kind of you.
Okay, just if you change your mind.
I'm not very tall, so, ballet mountain, standing there.
That's fine.
If I sit there, it's good.
Okay.
Lawyers like to stand and we like to talk, right? Those are things that we do. So I'm fine, but I do appreciate the concern. And the other thing too, the reason I was moving along is I want to make sure I don't go over because I do like to talk. So how much time did you want to make sure that what is my timeline?
You're about a third of the way through the presentation. And we're about an hour in. So
I know,
I
which
think,
is not good trend.
maybe pick up the pace in the middle part of the presentation and maybe allow some time for questions at the end. How does that sound? And I don't mean that,
Well, were you hoping that like if we
Rebecca
were
asked.
done by 9, is that what?
When does this not start?
Yeah, well, this is correct.
1 a.m. So let's not do that.
I can-
It's been done.
No, maybe don't ask that question.
Let's not do that. No 1 a.m. It's not teacher mediation. All right. Okay. So I can quickly go through this. other statutory duties of the board. We've talked about budget. Obviously, that's an important one of your responsibilities. We've talked about making policies. The policies are how you set those broad, and I said you guys are the big picture and the administration is the day-to-day. The way you codify that big picture is through your policies. We talked a little bit about how negotiations, I don't know how you specifically do your negotiations. Some districts have a committee, other districts appoint people just per contract. But in any case, any board member can serve on can under the law, can act as a negotiator in your collective bargaining. So that's another important function. All right, let's do a whirlwind tour of the Freedom of Information Act. What do you say? Okay, so meeting. What is a meeting? A meeting is a very broad thing. It is any hearing or other proceeding of a public agency, any convening or assembly of a forum of a multi-member public agency, and any communication by or to a forum of a multi-member public agency, whether in person or by means of electronic equipment, to discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. So what does that mean in English? It means that it's any sort of meeting at which the board, any of your boards, or committees of the board too, because a committee of the board is also considered a public agency. So any committee of the board or any board meeting or assembly of a quorum has to be a quorum of the board talking about a matter over which you have supervision, control, or advisory power. That's a meeting. So that doesn't have to mean, tonight. If in the parking lot, a quorum of you decide to talk about a topic over which you have supervision, control, or advisory power, that would meet the definition of a meeting, right? And so what happens when that happens? What happens when that happens is that there should certainly, that the public should have a right to hear that conversation. So the Freedom of Information Act is a statute which was created in order to ensure that the public had the opportunity to observe and hear and learn about the public business of public agencies. And so there are certain provisions that need to be done. We have to post the meeting. We have to have minutes of the meeting. We have to have our votes taken in public and not in a private executive session. Those things need to happen. Probably those things wouldn't be happening in the parking lot, right? So we want to be cautious when we do those things because we could have an issue where we're violating the Freedom of Information Act inadvertently. And if we did, then what might happen is that there would be a complaint with the Freedom of Information Commission, which would haul you down to Hartford to have to explain why you had the conversation in the parking lot. So try not to do that, right? Although Hartford is a lovely place in the winter time. All right. A meeting does not include personnel search committee. So if you're going to hire a new superintendent, which you're not going to do, because you have a fabulous and it's not just because of money, but then you're not going to do. But if you were to do that, right, you could do that in a personnel search committee, and then that wouldn't be a meeting because you have to be able to talk outside of the public in order to make those important decisions. A chance meeting or a social meeting. So you accidentally a quorum of you go to the PTO meeting. You don't have to freak out. That does not mean that it is a meeting of the board. It is just a chance meeting. So that is not a meeting.
Rebecca, if I invited the board to a Barbie over the summer,
I love
and we
it.
did like an Australian themed.
That's not a lie.
Right, if we did something and we didn't talk about business, is
Right.
that, what do you think about that?
If you invited them to a barbecue and it's not, you didn't talk about it, it's fine.
Or is it just perception wise, it doesn't look good?
It's okay under the law. You have to be
Right.
cautious under perception.
Yeah,
Because
yeah.
if you were to if people were like thinking you're having a parking lot conversation that I was alluding to a moment ago, you could have your neighborhood gadfly file a complaint with the Freedom of Information Commission and say, oh, they had a barbecue and I bet they were talking about,
Right.
blah, blah, blah. And then you'd still have to go down to Hartford and say, we weren't talking about that. We were talking about the weather. So it may not be worth it, but there's nothing illegal about it as long as it is indeed a social gathering and as long as you don't talk about where it is. All right, so strategy or negotiations with respect to collective bargaining. So that, this is exempt. You may have heard of something called a non-meeting. All that means, these things that are on my slide right now, the big X's, are the things that make up a non-meeting, meaning not a meeting. That's a special word that we lawyers have created for not a meeting. We call them non-meetings. But a collective bargaining can be done as a non-meeting, meaning we don't have to notice it, you don't have to have the agenda, you don't have to invite the public to your teacher negotiations or your custodial negotiations, or any of your collective bargaining negotiations. A caucus of members of a single political party, but it really has to be members of that public agency. It can't just be like a caucus plus 5 other great people who want to come. But you can have a caucus of a single political party, and an administrative or staff meeting of a single member public agency. So if Jason has a staff meeting, that also obviously is not a meeting under the law.
Now, to be clear, the collective bargaining would be a formal organized union, not
Correct.
an amalgamation of leaders, for example. Not that this exists, but say all 5 schools decided that their heads of school wanted to be collectively negotiate their salaries. But that's not a legal construct itself. It's not a union. Would that be considered collective bargaining?
No, I mean, there are unions that aren't like state affiliated. Like I do have some districts that have those kinds of amalgamations, and they are actually collective bargaining. They do recognize and bargain collectively. But just like saying, hey, this time I think it would help us all if like we all just kind of negotiated together so that we could get a better deal. That's not going to.
So if you took collective bargaining out of that sentence, it doesn't qualify.
Right, so there's no general exemption for just negotiations of the kind.
That's non-meeting, not executive sessions.
Correct, so what I was about to say was, so for instance, if you were negotiating about a central office person, right? That person is not in a collective bargaining unit, however, that doesn't mean that you have to bargain in public. What you could do is have, well, different districts do this differently. Some districts just have, depending on who it is, some districts would empower the superintendent to just negotiate with that person. And then what happens is the superintendent comes with a recommendation to the board to approve. So some districts do it that way. I would say probably many districts do it that way. Some other districts have a committee. And what the committee would do is have 2 things. They would have an agenda that's executive session for a personnel matter, because it's the terms and conditions of a person's employment. So you would have an executive session to have the back and forth negotiations. And then you would have a second agenda item to make a recommendation or approve the actual contract. So you could have the discussion in executive session and not in public, and then just vote to approve it. Or, as I said, you don't even have to have a formal meeting. You could just empower the superintendent to discuss it with the person, because the superintendent can't approve it. It's still going to have to ultimately go to the board to approve the ultimate decision. So the board is going to make the decision in the end of the day. It's just a question of how you want to do the back and forth discussion part.
But the personnel, the executive session would qualify under the personnel part of it, not the negotiations.
Correct. It would be an executive session for a personnel matter rather than a non-meeting for collective bargaining.
Personnel matter could mean performance, it could mean compensation. It could
Correct.
mean anything like that.
But personnel.
Correct.
And for that executive session, we just did this right before this meeting. So we had a couple of
Did
members.
you do it right? No.
I think we did. I think we did.
Okay, good.
However,
Yeah.
we actually had a couple of members who were early or were really interested in being as sort of a part of that negotiating committee meeting. And because they were here, we invited them into the executive session. But because others weren't here yet, we couldn't invite them into the executive session. And it felt terrible turning people away to say, you can't be in here. These are members of the board that you're turning away. Would we be able to just say any members of the board are invited in as they come?
The only thing I would say that it gets a little bit gray is that that is a meeting of your negotiations committee.
Right.
Right?
That's correct.
So if you have all the board members,
Yeah.
then it sort of looks like a meeting of the board, which
Yeah.
isn't necessarily a violation of the freedom of information, because you've already noticed it as a public meeting, the
Right.
public can come. But but it does become complicated because the board members, if it's a board meeting, different people are empowered to act.
Right.
And if you start having all those people in, it does kind of confuse the public as who has the power to make decisions. So you might want to invite them in, but be abundantly clear that they are there only as an observer and make sure that those board members don't chime in. So like if there's a conversation about that personnel matter, I wouldn't want the other board members to be like, oh, I don't agree, even though they have every right to say that at the board meeting that comes after this.
Right.
It would be a little confusing, I think, to do that in that meeting.
Not to beat this horse totally to death, but the other side of that coin would be that the executive session provision in the FOI Act says that non-members of the agency can join, but only for a limited period of time in which they can contribute something of purpose, and then they have to leave.
Right.
If you're having board members just to observe, they're not actually serving any function, they shouldn't be included.
Yeah, it would be unusual to do this, and I do think it would be kind of confusing. But I don't know if it would invalidate anything or really cause a major problem, but I do think it kind of looks wonky.
Thank you.
Okay, types of meetings is my next slide.
I have a question about this one. So,
Sure.
Can you define caucus in this circumstance?
It just means a group of members of a same political party who are having a discussion about something related to board business. But what's complicated, the tricky piece about the caucus is it really has to be one party. It's a discussion of only by members of a particular party. So it can't be where people get in trouble usually, like what I alluded to before, is where it's one political party and then one extra person. It really can't do that. It has to be a discussion by one particular political party on a particular topic.
And the second half of that is it has to be less than a majority of the board.
No,
It could actually be a majority.
Yes. Well, it depends on, obviously, it depends on who makes up your quorum and who's on the board, et cetera. But yes, it just has to be a single political party, because it's okay if they constitute a quorum. But it really, as I said, where people get, it's usually just the fact that,
How does that not completely negate all of these other parameters?
in terms of like just open meetings, you mean?
Well, you're like, on the one hand, everything we're discussing is all about, you cannot go out in the parking lot and have 4 people have a discussion about board business, because it would cause all sorts of problems and complications and be potentially expose and liability, what else?
Right.
But it's okay for, say, Region 9, for 4 members of one political party, even if they constitute a majority, even if it would constitute a quorum, as long as they're all members of the same political party, they can go out in the parking lot and have this meeting or discussion. It's
I mean,
just
I
like-
can't answer to why that's in the
According to the
statute,
law,
right?
that's
But yeah,
that's
the statute does allow
Yeah.
a caucus of one political party to have, I mean, I guess they are just banking on the fact, because obviously in order, they're banking on the fact that even if you can have this discussion, ultimately the full board has to make a decision.
I think the statute, you have to remember, is written not for school boards, but for all public agencies. And so there are hyper-partisan public agencies for whom having caucuses is a part of their sort of normal course of business, where school boards don't typically operate like that. But I can consider sort of a broader commission or a legislative council where it's held by control in one party. They all go in caucus, they deliberate there, and they come back into public session.
Correct.
That's what it's sort of used for. It seems like it's part of a grand bargain for the legislature 50 years ago.
Right,
Probably right.
it's just something that's been in place for a long time. I guess the other thing I will say, in working with boards of education for whatever, 19 years or whatever crazy thing it is at this point, I would say it's very, I can't always tell what political party people are on, I will say. Because I don't always find that people vote based on their political party. So I will say, although I don't think that this has been in effect for a long, long time, and everything that was just said is absolutely true, but I will say that oftentimes issues aren't decided by politics. I've been very pleasantly surprised in doing this as long as I have, is that really, because the issues aren't always politicized, right? They're about students. People have different needs. That doesn't mean it's always going to be that way, but I guess that's how the law functions, is that You're supposed to make decisions as a board, hopefully based on the issue in front of you and not based on your politics, but I can't defend the law. The law just is what it is. But yes, it is legal to have a conversation by a particular caucus of one.
Is the tri-board considered a board, or is it considered, are you still 3 individual boards at a tri-board meeting?
We are still 3 individuals,
I
but
think
we are
you're-
always 3 individual boards.
We're actually
Region
3
9,
separate boards at 3 separate
Easton.
meetings
Right,
All
being
convened
held
on-
concurrently.
that's right.
You guys like complication.
That's right.
Right?
And that's,
These are
how we
attended,
vote.
I'll give it tonight.
Always vote separately, right?
Yeah,
Reading, Easton, Region 9.
wow. Good time, all right.
That you're surprised that that worries me, because we're not the only district that exists in the state, but okay.
Well, so
We're
I,
there for-
yeah, Region 4 is a little crazy. I think I work with them, but I don't know, we need to have a competition about who's more challenging.
Oh, bring it.
Right, they can be challenging too, but anyway. Regional boards provide extra interest and enjoyment and opportunities for learning, right? Okay, that's always what Tom Lee used to say to me when he wanted to give me a task I really didn't want to do. It was an opportunity for learning. So, all
But
right,
I'm sorry, just to Kathy's question, is that related to the caucus question? Or is there a sort of extra question there, Kathy, related to some of the non-meetings and meetings across the boards?
Well, I was asking to just clarify, as a tri-board, is
Yeah.
that considered a board in and of itself? Or is it actually 3 separate boards? So then a tri-board, those things don't apply to a tri-board meeting in and of itself, but it's each individual board.
but the rules are the same, right? So if the rules that we just talked about apply to each of the 3, right? Individually, so. And the caucus is based on a partner and not necessarily a board member. All right, types of meetings. There's 3 types of meetings. I have to do this pretty quick, I think. Regular, special, emergency. Regular are the ones that you schedule in January that happen once a month, that are posted in the town hall and online. Special are meetings that aren't on that list that you do in January that come up from time to time that address a particular issue. And emergency are ones that should happen extremely rarely. I'm not sure that I can think of very many instances at all in my entire career of doing this that they would come up. But emergency meetings are limited to, if emergency is truly emergency. It's not like, oh, hey, we forgot to do X, Y, Z. It's an emergency. No. It might feel like an emergency to you, but it's truly emergency. Like there is no way you can wait the 24 hours to post a special meeting. So just to back up really quickly, the regular meetings, the agenda has to be posted at least 24 hours in advance. You have to have minutes available for public inspection within 7 days of the meeting. And new business can be added on the day of the meeting. So if 2/3 vote of the board wants to add something to the agenda, that can be done at a regular board meeting. That is the major distinction between a regular board meeting and a special meeting. Under a special meeting, which is the next slide, you cannot add to the agenda. The agenda is the agenda is the agenda. So once it's up and posted the 24 hours in advance, those are the topics you can discuss. You can't add to it the way you can in the regular meeting. But all the other things are the same. You still have to have 3 minutes. They have to be posted within 7 days of the meeting. And then emergency meetings is the last one, as I said, and that's truly very, very limited. There's absolutely no way you can have this meeting and follow your 24-hour posting. You must have it. Without that, then you can go ahead and have the meeting, but then you have to file with the town clerk within 72 hours, the minutes, and you have to have a statement in there, particularly what was that emergency, and it can't simply be, oh, we forgot to do blah, 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 right? Okay, so those are meetings very quick and dirty. Any questions about meetings?
Quick comment tonight's meeting is actually a special meeting, even though it was on our schedule of regular meetings, because we approved that in Easton and Region 9 within the last 30 days. So this had to be a special meeting because that scheduled regular meetings had to be that way. It's actually the same for our regular meeting next week. On Tuesday, there weren't 30 days. So next week is actually a regular, but special meeting.
Extra special, regular.
Extra special regular.
All right, excellent.
And
But not
so-
emergency. Okay, so executive session, we talked a little bit about it already, so I'll just quickly go over it. Executive session, we need 2/3 vote to enter executive session. The motion has to be clear as to the reasons for executive session. There are specific limited reasons you can be in executive session because the statute wants your business to be done in public. So we've alluded to some of them. You can have executive session for, the first one is the personnel matters that we were talking about before. And that is discussion of appointment, of employment, performance, evaluation, call for dismissal of a public officer or employee, subject to the individual's right to have that discussion be held in public. So like, as I said to you before, like if there's a teacher personnel matter and let's say a teacher got suspended and they're grieving it and we're having a hearing and the teacher, we say, we'd like to hold this in an executive session to protect your privacy. The teacher can say, oh, no, I want to have it in public and have everyone hear it. That is something that there's an opportunity to have it in public. You have to be specific on the agenda. You can't just say personnel matter. You have to say discussion concerning the employment of a teacher. It doesn't have to say, discussion concerning the suspension for the teacher's horrible decision to do that. Not that specific, but specific enough that the public knows what you're talking about. Discussion concerning discipline related to a teacher. Discussion concerning the employment of the superintendent of school. Something more specific than personal. Another reason that you can have executive session is, it's missing it on there, but it is pending claims and litigation. That is, like I said to you before, like in those rare instances where I've had a special ed matter go to appeals court, we might go to the board, the pending claim and litigation, and say to the board, we're about to go to court. Do you want to resolve this? Or do you want us to move forward? There's an ability to have an executive session to discuss a pending claim and litigation. Security strategy or deployment of security personnel. Obviously, that's another thing that would be important to be able to have in public, right? Because if we were to tell all the bad guys exactly how we handle our security, that's probably not wise, right? So we have to be able to have our discussion regarding security strategy privately, so there's an ability to have an executive session about that. Real estate matters. There's an ability to have an executive session about real estate matters. That's really just to protect your ability to negotiate. If you were going to negotiate about the purchase of specific real estate, you need to be able to do that privately. And then finally, what's also for some reason missing from the screen, it's in magic ink. I gave it to my 7-year-old, I guess, is discussion of confidential records is the other executive session reason. And that is what I was alluding to before about the discussion of confidential records would cover student records, right? That's how we do our expulsion hearings in executive session. That's how we do our residency matters in executive session. All right, I had an executive session scenario, but I kind of feel like I should skip it because we need to properly share it for taking too long. I mean, I think we talked a lot about executive session, so maybe we'll skip the executive session scenario, unless people really want to. Committees, my next slide was I did put your bylaw about committees, although I think we had a good discussion about committees. My main point that I wanted to say about committees was that they're covered by the Freedom of Information Act, just as any other, and that they have to make decisions and then bring it to the full board for ultimate decision. And then finally, I have one last thing on executive session, is just overview of what I've already said, I think, which is that it's not an agenda item. So an executive session isn't a particular thing. Some places think they can just put at the bottom of their agenda, personnel matters. And then if anything comes up, they'll just address it then. Not so much. You can't do an agenda item to just cover that. It has to be specific to what the topic that you're discussing.
But you don't have to put executive session on the agenda.
You
It's
don't even have to
it's
put it
a
on the
procedural
agenda.
thing.
Correct. Some districts like to say proposed for executive session out of a courtesy to the people, right? So it doesn't have to be on the agenda at all, but I think some places frequently say, we're going to have a grievance hearing proposed for executive session so that the public knows that they shouldn't plan to stay for that part. I and they don't feel excluded when they're asked, because it's not something difficult. But that's true. It's not open. You have to invite who you want to attend the executive session. You can't take action in executive session we talked about. That has to be done outside of the executive session. What is discussed in executive session should remain confidential, because it is pointless to utilize our executive session privilege and then share the information that's disclosed within, right? And all those liability things that we talked about before. If you have an executive session, there is a reason that we have decided it is important to have that conversation confidentially. So we trust board members to maintain the confidentiality of what is discussed in executive session. And obviously we don't want to have all of our meetings in executive session. We want to strike a really good balance where the public feels involved and engaged in our board meetings. But obviously we want to utilize when we need to be confidential, we're going to utilize our executive session, because we're not going to put ourselves in harm's way or prevent ourselves from having meaningful discussions that truthfully can only be had confidentially. All right.
So I have a question about this one. So if executive session does not have to be an agenda, item, that also includes if you have an emergency or special meeting, right? Is that only in the context of regular meetings?
No, it never has to be on the
You never
agenda.
have to. do it.
But the thing about it
Oh.
is that you can't remember, you can't vote in the executive session anyway. And in a special meeting, most districts, as I said, the way they handle it is, like, it depends on what it is, but let's say let's go back to our discussion of a central office contract, which we were talking about before. So you could put on a special meeting, discussion of the contract of the business manager, right? But your agenda item would say, discussion regarding, proposed contract for a business manager, and then you could put proposed for executive session in parentheses. And then the next agenda item could be possible action to approve business manager's contract. Then,
But if the agenda just said business manager's contract, you can both go to executive session and
You could
approve
do
the
it that way,
contract.
too.
Is that sufficient notice?
you could do that way. The only thing that's negative about that is that people might be mad that, hey, I thought I was gonna get to hear your conversation about the business manager. So the reason we put the proposed for executive session is purely a courtesy to tell people, hey, we're gonna talk about some part of this in private, and then we're gonna make the vote.
To Cheryl's point, if she comes to a special meeting and the agenda just says business manager's contract, and she says, I'd really like to have a private conversation about it, she can ask for an executive session, there's no problem with that.
Correct, it just might anger the public. But yes, you could do it legally.
Right, with the 230 vote.
Sorry, Mike.
No, it pertains to a contract.
As long as it has to pertain to what's on the agenda. It can't be on totally unrelated. But if it's already on the agenda, yes.
And anyone can be invited into the executive session?
In the, as long as they're, yes, anyone can be invited. It can even be people who aren't on it. So sometimes you
long
can
as-
invite me into your executive session or.
But you have to be invited, there has to be a relevant
You have to
reason
have
for you to
some-
be there.
Right.
Yes.
Yep.
So like you would invite your attorney,
Right.
let's say the attorney was coming, to go back to my example of the litigation. If you're going to have an executive session on pending claims and litigation about a federal lawsuit, you might invite your attorney to come into the executive session because I have pertinent information about whether or not to resolve that lawsuit. All right, moving on. A couple things about, I talked a little bit about being cautious about meetings. I also want to put a quick caution about messages. We talked a little bit about text messages, but to just follow up a little bit about electronic messages. So any communications by a quorum of board members can be, when we looked at the meeting definition, I said to you that it could be any sort of convening, even if it's in writing or online or, so it can be any sort of modality. So you want to be really cautious about what you say to other board members. And also, even if it happens not all at the same time. So if one board member writes to another board member and says, hey, I want to talk to you about my thoughts on such and such topic. A day later, that person says, here are my thoughts. A day later, another person chimes in with, here are my thoughts. That, the Freedom of Information Commission looks at that series of events as that conversation. And if it gets to the point where there's a quorum of members of the board having that conversation over email or text, it could be a little legal meeting. So you want to be very cautious about having conversations over email or over text that could constitute that discussion by a quorum of the meeting. And also,
something
yes,
related to this? So, this kind of comes up, I think, sporadically, especially now with COVID, where state guidelines come down and, the public is waiting to hear what the state's gonna say. So they might reach out to us, but they might blanket email everyone from all the boards.
yes.
So then I know we're not all replying all because we don't want to
Because of
have
this reason, right?
yeah. But should we assume that the chairs are responding or one chair is responding from all of the, like, what should be our understanding? Because I also don't want the public to feel like they're not being heard or responded to, even though there's however many of us on the email.
I would take the position that there's nothing wrong with acknowledging receipt of something. That's different than deliberating on the issue or sort of commenting favorably, unfavorably on what somebody said.
Right.
Well, you just don't want to have a split discussion, right? So that's what we're trying to stop, is that, so anytime it's reply all, not a good plan, because like, if nothing else, it just prompts further responses, right? And it just treads into the dangerous waters, right? So I think you're right. It's a good for you to figure out who is going to respond to them. Somebody needs to acknowledge what
The
those
way
are.
the way that I see it is, if it's a parent of a SSES or HKMS student, it is my responsibility as the chair of the Easton board to respond to that parent, acknowledge receipt, etc. If it's John Reed and Reading Elementary, I know the names of your schools. And what I did, and if it's simply a citizen of Easton, it's me, a citizen of Reading. It's gross, but
I think the chair typically will respond with an acknowledgement. I think it's also to the point raised before, it's okay for you to say thank you for your email, Mrs. Smith. There's nothing wrong with that, and that's,
Don't
good
copy all the
form
board
as
members
well.
on it, just-
Yeah, well,
21 of us can respond back to one.
yes,
As long as we don't copy
but
everybody.
you can even respond to everyone and say, thank you for your email, Mrs. Smith, right? Where it gets tricky is deliberations related to board business, right? So anytime, we can have an email all that says, can you make a meeting on Tuesday? That's informational, right? Something like that. But when you start deliberating on board business, now you're into an online meeting. So if you responded to one parent and said, thank you for your email, Mrs. Smith, I'm sure Mrs. D'Agostino is going to get back to you, and Dr. McKinnon will give you further information, but thank you for, that's totally fine. It's just when you start to get into the
You just
deliberation.
don't, it's really about between each other. So what you don't want to do is see that she wrote that email and then write back and say, oh, well, you forgot to mention this. And then another person
Yeah.
says, oh, you forgot to mention this and tell her this. No.
But if we all independently, pick whatever collective body, got an email about, I don't like whatever, this, that, or the other thing.
Right.
If we all individually responded, just to acknowledge that receipt, that's perfectly fine.
Correct.
But isn't it okay for us to, as individual board members, not copying everyone?
Right.
To actually engage in a back and forth with that person, if it's just the one board member and the person?
But, as you go to my next slide, yes, but it'll be a public record. So you better be awfully careful about what you're saying. Because whatever you're saying is going to be a publicly disclosable record. And when that person gets mad at you next month because you don't answer a question in the supermarket, and then FOIs all the things, then all your emails would be disclosed. So you just want to make sure that whatever you said to her is what you're supposed to be saying to her and is in line with, what's appropriate. Because inadvertently did something you regret, then
Makes sense.
Just before we leave, on the previous slide, you were talking about, even if it's not happening all at once, if you have an email exchange on a topic with two
Right.
board members over here and then the same topic with two over here, isn't it also true, even if it doesn't happen via email or text, if you
Right.
call,
yes,
if I called every member of my board to test their minds on a subject, that's a serial meeting as well.
correct.
Yeah, okay.
shouldn't have discussions, whether they're happening instantaneously or in sequence about a topic which we're not inviting the public to hear. That's what ultimately the law is preventing.
It doesn't apply to 9 minutes. So I could have a serial conversation about collective bargaining.
You can have a serial conversation about like any of those things that I said are not a meeting. You can have a serial conversation, you can have it in your personal search committee, you can have it in your caucus, you can have it in your collective bargaining, but if it's a meeting, right, if it's one of the topics that. Other than those very specific limited exceptions.
If we constitute a committee of the whole for some personnel search purpose, we could email everyone around. That's not a meeting because it's a personnel search thing, right?
Yes,
However, that email that went around is still a discoverable email,
Yeah.
right? It's a public record.
yes, unless it's exempt under one of the reasons. That it's
Okay.
exempt. I mean,
So for some
there's a-
other reason.
Right, but there could be some other reasons, but
Right,
unless
okay.
it's exempt. I'm not gonna lie, because it's probably some topic that you couldn't.
Are we gonna get lawyer certificates at the end of this?
I know. Some of you-
Get your wire back.
Some of you are
Stick it on
definitely
your
keeping me on my toes. I will go back and tell Rich Mills that you kept me on my toes. Okay, so we'll go to the next one, just because I want to move us. Where email communication is unilateral, but we've already talked about this, is that like, if it's just unilateral, it's not that serious, and we don't have to worry about it.
And that can include sort of the chair sending an email to the whole board before a meeting. Here are the topics we're talking about.
Yeah.
Here's what we expect to sort of get done, so that everybody's sort of primed for the
Yeah.
agenda.
But what you need to make sure is to train people not to respond to that. Say, oh, what do you mean? Blah, blah, blah. No, just here's the topics. Please do not respond to this email. This is simply a notification. Yes, you can, that is perfectly allowable and commonplace in today's day and age. But what we don't want to do is generate responses. So we want to make sure that everybody, when they get those messages, they don't reply all, they don't even reply to some to create that serious discussion. Yes.
Right, I have a nitpicky detail question sort of with this, like I'm kind of picturing my inbox, right, and say, John sends us an email, informational email, and if I reply as a separate communication that I initiate, do you know what I'm saying? That it's very obvious
On
to
the
me
same
that-
topic though?
Yeah, I guess, but I mean, somebody would have to really scrutinize, I suppose, whether or not, it's considered the same topic, like you pull something.
Well, the Freedom of Information has a lot of free time. They do scrutinize. So I guess, obviously, as a lawyer, right, I want to tell you to be cautious. Anytime that it's going to become a discussion, right? Anytime the topic is evolving, it's a series of, it's a continuing discussion among the forum of the board, I'm gonna worry that it's a meeting. If it's not, if it's just a communication about a separate topic among two board members, that happens, right? I mean, a board member can contact one other board member. That happens all the time. I'm sure the chair sometimes talks to a particular board member about particular issues. That's okay. What we don't want to have is this conversation, it starts with this, and then it talks to these two people about this piece of it, and then these two people chime in on this. Then if ever there was a complaint in front of the Freedom of Information Commission, I'm joking, but their role is to make sure that those kinds of conversations are had in public. So they're going to look at it with a lens of, did this constitute a discussion that the public should have been a party to? So I would say exercise caution, but also reasonableness. You can have a conversation with one or two other board members. That's fine. That's not gonna happen unless they're forum, but
It was really just a technicality question as to whether or not, like, a response to something sent to you was viewed differently from you starting a separate communication, where you're not just replying to someone. You actually
yeah.
you
I
take
see what you're
you take
saying.
yourself out of the chain and then separately
It helps.
address it to the person.
It
that's-
helps.
that's
I don't
different.
know whether, it depends on the specific circumstances about whether I think the Freedom of Information Commission would be persuaded that that separation was enough to end the conversation. have to look at the specific. But it certainly helps, right? Anytime we move away from that large group, it's better.
And it may be that I'm the only one who knows that, right, if Jenny just replies to me, so far we're good, but then Devin and then Jen and then Randy, I might be the only one who knows that, hey, we've started to engage in a
Correct.
serial meeting here, so it's contingent upon whoever's the nexus of that
Yeah.
to say, well, hold on, we gotta move this to actual.
Correct. Agreed. And obviously, I'm telling you the most cautious, right? Because if we want to avoid potential issues, we should be the most cautious. But
I've had a question not related to email, but in social media. I don't think I saw anything in the deck here about that. That if board members post something in social media and then other board members start posting other responses to that, or start engaging the public in conversation in the posts in that social media site. How is that being for board?
well, you know, Floyd was written a very long time ago, right? I don't think there was Facebook back then, but I would say anytime it depends on who you're engaging with, right? So a board member on Facebook engaging with a member of the public isn't engaging amongst yourselves. But if a forum of the board is having a discussion, I don't care where it's written, I worry that it's in the resolution, and I would advise against it. So if the board members are communicating about a topic over which you have control on social media, I would say yes, that would worry me, that would be illegal. All right. Moving on. All right, briefly, here's a public comment scenario. Do you want to do it, or should we skip the scenario because we're getting one out? Let's do the scenario quickly. And then we'll try it. During public comment, a parent got up and began complaining about a teacher at the high school. Before she could get very far with her statement, a board member interrupted her saying, we don't allow comments about individual teachers, as that is a personnel matter. The chair then asked if the long line at the podium planned on speaking about that same teacher. When they all nodded yes, Bob Bombast made a motion to suspend public comment for that meeting. The motion was approved unanimously. Is this okay? Or are there, so what do we think? Can we?
Subject to our policy that we don't allow public comment on personnel matters, yes. If we
I
don't have
did
that
see this in
policy,
your
then-
policy, right? So here's the thing that I will say, what this scenario is about, and maybe it will make you take a look at, because I did see this in your policy, is that maybe have you take another look at it, is it's okay to say that you don't allow people to talk about teachers. However, then they can't talk about them positively or negatively. You cannot just limit the negative under the law. So that means that if a person from the public wants to get up and say, Mrs. So-and-so is the best teacher my child has ever had, she's changed his life, we would have to stop from that too. And the reason being is that public comment is a public forum where we are allowed, where we cannot, we can't control viewpoints. We can only control the nature of, we can put controls on the number of people, the amount of time, the time in the meeting. Truthfully, you don't even have to have public comment. Public comment is not required. There's no law that says you must have public comment. However, every board that I work with has public comment because the public wants to be heard at the board meeting. But you have to be cautious is that in public comment, you can't control people's viewpoints. You have to, whether you agree with it or disagree with it, you have to let them be heard. The other piece that I want to get out of this scenario is that generally I don't recommend having conversation with the person who's talking in the public comment. One, because it's not on the agenda. Two, because it tends to create chaos in your meetings. And three, because I think you want to decide after the meeting whether it might be something that someone raises at the meeting that you want to put on a future agenda or it might not. Give yourself that opportunity to decide that. So those were my points about the public comment that I really just wanted to get across. All right. So at this point, I'm basically done. I have, at the end of my slides, I've done some best practices for board meetings. I don't need to go through all of those right now with you. Because this has been very lengthy and it's after 9 o'clock. I think what I would just say is that you should read through them. They're hopefully helpful to you. I think that it's a very complicated thing to be a board member, but it's a very admirable thing to be a board member, and it's a wonderful thing. And I think that it's great that you all are here. It's great that you're willing to be here till 9:15, listening to my presentation, engaging, asking great questions, and wanting to do good for your community. So hopefully you can review those after. If you have any questions about some of the best practices, I'm more than happy to talk through them, but I also just don't want to keep you here forever either, because I know you probably had a long day and there's just no stuff coming.
Early nights.
Well, here, Rebecca, and given your experience across the state dealing with a diverse group of different boards, can you talk a little bit about sort of the qualities that make boards function well and the qualities that make boards function not so well?
Yes. I mean, I think the things that help boards function well, and we can look at some of the things that I think do and don't, I did some do's and don'ts. If you want to go to the don't page and the do's. I think that the best thing, good boards have good communication with each other. They have clear understanding about who serves what capacity. They operate well with each other. They don't criticize each other. They're respectful of each other. They have clear understandings about how they're going to interact with the public. So for instance, when I was talking about the public comment, they have a clear understanding about we don't have back and forth discussion. We do let the chair decide what's going to be on the agenda. Strong boards have clear understandings about those kinds of expectations. They don't engage in any inappropriate behavior. They're respectful of each other. They're ethical. I think the other piece is they work well with the administration, and that's not even on the slide, but that's key, right? The boards that I know that function best function well with each other, have good communication with each other, and have trust and respect for their administration, and understand the importance of both parties' roles. They respect each other. The superintendent understands the really important policy role that the board plays, and the board understands the really important day-to-day operational needs of the district and what that superintendent does and what he doesn't do, and are respectful of his time and don't overwhelm him with too many questions that he doesn't have time to answer, but at the same time asking good questions. So I think good board members work well with their administration, work well with each other, have good communication, and are basically just good citizens in general, right? They treat people with respect. They treat the public with respect, and they treat each other with respect. I don't know if that answers your question, but that's
The only thing I would add to that is that you also evaluate or you reflect on what Rebecca just talked about. So how well do you do those things? And is there room for improvement? And just spend time thinking about ways that you can be more efficient or effective, ways that you can maybe set stronger goals for the district, and so on. So I don't know if you've ever done board self-evaluations. You've reflected on that as a board. But that is a way in which to evaluate yourself against those criteria.
I think the other thing too is have good discussions about, what are your expectations? Like, how many committees do you want? Do you want to be out every night? Do you want to be out on left nights? Do you want to have certain people serve different roles? Those are important conversations to have. Boards that function really well have a clear understanding of a balance, right? Of utilizing people's time effectively, having people be heard, but not overwhelming anyone with too much, right? Because if you reach that saturation point, it's hard on the board, it's hard on the district. It's not optimal use of time. It all comes down to communication and what your board wants, right?
Yeah, thank you very much.
All right, well, I hope it was helpful. It was really nice to be here with you all, and I hope that maybe I'll see you again. If not, I hand you back to Rich Mills with, I'll tell him that you guys were all very well behaved. And,
You don't have to lie.
Make sure there's no questions.
Yeah, very good. I'm hoping everyone on Zoom can hear us all right. Any questions for our remote board members?
None for me.
Thank you, Laura. I saw Jeff shake his head. Randy, anything for you? No. Okay. Very good. Great. Thank you very much. All right. That will take us back to our agenda, which has us at joint board committee reports. This time I'll look for any joint board committee reports.
John,
Yes, sir.
This winter, unless the state directs us otherwise, we should be going through the process of an RFP for food service. And so the food service committee, which is made up of one person from Easton, one from Reading, and one from Region 9, should meet sometime in the next 30 days to start that process.
Thank you, Jeff. Any additional joint committee reports? I'll briefly give an update on the joint negotiating committee. We did meet, spent some time negotiating the executive session. Plan to meet again in early February to dive in a little bit more and try to get to a point where we're able to contribute in a meaningful way to the central office budget before it's decided as a part of understanding what we plan to offer our senior staff. I'll also make a quick pitch for the joint policy committee. We continue to meet, and we have been having some conversations with Jason, Dr. McKinnon rather, about the possibility of switching our core policy starting point, which has been CABE for years, over to a shipment policy manual that looks really promising. We did some initial investigations looking through the policy manual that Shipman produces, their process of submitting updates and sort of, hey, there's a new law that we need to get right with, and sort of Shipman's speed to getting there, and the skill with which they're crafting really great language. Nothing against CABE, but there oftentimes is a little bit more reworking that's necessary there that can be really onerous and take a lot of time from the committee. So there's a strong possibility that we're going to come back with a recommendation at our next tri-board meeting that we sort of go with Shipman as the base there, but we'll obviously be a lot of discussion about that when we do.
So you realize that's, we've had CABE for many years. And then 2 years ago, 4 years ago, three years ago, maybe, we actually switched to have Shipman and Goodwin, and we paid that initial fee for the 3 boards to be able to get their policies. That was all before the many years of policy on Fridays work began, and they've been saying for years that it just seems silly that we don't have the policies of the firm that's going to be representing us if there was an issue with the policies.
Right.
And that we already paid that introductory fee. And when I spoke to Shipman the last time, they said that because we've already done that, we could just go into paying the $1,000 a year for all 3 boards or whatever, and just be done with it. Have their policies, they're all posted online, you get updates. And that is very much the direction I would love to go in, and
Well,
I didn't hear that.
Good, and Jason pushed us that way. To be clear, we would still review all the policies and make sure they're consistent, and there'll be a process, but I think there is a strong indication that we're heading in that direction.
That is news.
So it almost sounds like it's cost neutral or lower.
Yeah, I think that's gonna be the case.
It's de minimis.
It's
Yeah.
so small.
It's really small, and I think it might even be less.
Time saving.
And if you're super curious, you can look at our last meeting on YouTube and
Yeah.
the discussion about the minutia.
It was very promising, and Jason was able to, because Dr. McKinnon had just done this in another district, and so was able to bring up examples of, this, sort of how the updates work and all that. And it was exciting to those of us who live in group policy. Why are you laughing?
If we do go with that, let's just make sure you're aware that you
Yeah.
did pay that
That's-
$3,000.
I did not know that, so that's very helpful. Good. Okay, so that's it. For me, any other joint committee reports?
I assume that by the end of the month, we'll have all the joint committee assignments refilled from all boards.
Right. Easton has done our process.
Well, we kind of paused because there was talk out there that there was gonna be some readjustment, realignment, compression, condensing, whatever was gonna go on, but I think the approach that I'm gonna take at our next minute meeting is just to fill all those positions again, and then as that happens, it happens. But I don't wanna be in a position where we need a meeting and we don't have that.
Exactly.
The position I took in writing was to make sure we had no unfilled positions, with the understanding that they were also conditional assignments pending a further discussion about how we consolidate or rework.
So there is the discussion of three separate boards, we do convene together, that we might reduce the number of meetings on.
The number of committees, yes, that we may combine committees, and we believe that the way in which we collapse those committees for any committees that have created a regular schedule for 2022, we believe that if we consolidate the committees in the right way, we can still keep that schedule if it makes sense to keep it. We still have the regular meetings, although it's not the end of the world to just set up a special meeting.
When are we planning to consolidate the committees?
I think it'll need to be a topic that we bring up in an upcoming tri-board. It's just the agendas get very crowded, especially as we approach the budget tri-board conversation. So it's unfortunately, it may not be until not this next one, but the one after that, which is
So it needs to be February or May.
right. So it may not be until May.
I did, yeah, so I think I presented those in October. I've got kind of a framework for establishing 4 broad buckets, where, like, for example, you could say finance, operations, and personnel could be and in operate, obviously finance, you'd be looking at finances, but in operations, you could do, I heard you mention food services. So instead of having a food services committee, you bring the food services RFP to the finance committee. Same with the bus contract.
So we would need to come up with a really specific proposal for the, how they would be consolidated and then discuss that inside of, I suspect, the May tri-board meeting. And
My recollection from October was that there was a general consensus that it was a worthwhile endeavor to continue to look at. And so if we were in a position to put together a concrete proposal for February, great, we just have to understand that it can't be a 3-hour discussion about it because there's a lot going on.
Was there more on the kind of ways of working, governance practices, if you will, that we last discussed before the boards reconstituted? Is that going to continue, or what's the next steps in respect to that?
So my recollection of that was that, and that was a policy committee, it started in the policy committee. My recollection of that is that we actually made it through all the recommendations and had broad agreement. While it started in the policy committee, we did determine that this is not a function of policy. It's a broad agreement that this is the way we work. It may be worthwhile to briefly review or even just circulate the sort of consolidated form so everyone can take a look. And then if we need to raise because we have disagreements about anything that's summarized on there, or we think we need to add more stuff, we can do that as well.
I would take the items that you brainstormed in that committee and actually, along with other tools, and try to turn them into some type of evaluation rubric and evaluate, are you doing those things at the board, rather than having a committee meeting about how to do those things.
I like that. I think Jeff is acting as secretary tonight, so I'm hoping he captured that. If not, YouTube did. All right. Anything else in the joint board committee reports section, which Lou is there? Okay. Good. Then I think we'll look for some adjournment motions.
Mike, second, Sharad, any objection? Ready, jump the gun, is adjourned at 9:28.
So it's motioning to adjourn here at Easton. Do I hear a second? Thank you, Jen. Absent objection, Easton is adjourned at 9:28 p.m.
Sarah, Sarah.
John, you both gotta go last.
Very good. Thank you very much. Yeah, enjoy this now.